Everyone, I'm Leonard French, your favorite copyright attorney, and we have a heck of a story for you today. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. This is the Dark Spilver Reddit DMCA subpoena. You may remember this from last April. A religious organization called the Watchtower Bible and Tract Society, otherwise known as Jehovah's Witnesses, had subpoenaed Reddit through a little-known provision of the DMCA, DMCA 512H here. Let me see if I can get it up real quick. DMCA 512H, if we scroll down here, and if I move my face over and maybe flip it around. DMCA 512H down here allows a subpoena for an identity. Here is a request, contents of the request, contents of the subpoena, basis for granting the subpoena, and all that. We've gone over this in previous Dark Spilver, Watchtower, Jehovah's Witness, Reddit videos that we will link, I guess, not during the live stream, but after. And this is now finally 10 months later or 11 months later, we finally get a ruling from Judge James Donato in the Northern District of California. If you remember, the EFF, the Electronic Frontier Foundation, stepped in to protect Dark Spilver's identity. What was Dark Spilver guilty of? They had posted a back page from the Watchtower magazine. The back page was an advertisement, a request for, here's how you can donate funds to Watchtower / Jehovah's Witnesses. And he had posted it, he or she had posted it to Reddit with a title, something along the lines of, can't believe this, or something like that. It was a very simple title. And then he also, or she also posted a table, like an Excel spreadsheet, which was the internal policy of how Watchtower responds to GDPR requests or GDPR problems, the data privacy regulation in the EU. And they had also posted that to Reddit. And both of those were attacked with this DMCA subpoena provision looking for Dark Spilver's actual identity. And there was this big controversy over whether they were genuinely seeking a subpoena to enforce their copyrights or whether they were using copyright law on a religious crusade to identify a dissenting congregant or member of their religion. So without further ado, let's get to this decision and see what the judge has to say. So this is Judge James Donato in the Northern District of California, in re DMCA subpoena to Reddit, Inc. And this is the order on a motion to quash. What is a motion to quash? It's a motion, well, a motion is a request to the court, and a motion to quash is a weird way of saying we want to cancel or negate or vacate the subpoena. We want to oppose the subpoena. So that's what we do. We file a motion to quash. Dark Spilver, a pseudonymous user of Reddit, the online social media and discussion site, seeks review of a magistrate judge's decision denying a motion to quash a subpoena issued under the Digital Millennium Copyright Act 512H. The Watchtower Bible and Tract Society served the subpoena on Reddit to uncover Dark Spilver's identity after he posted images of Watchtower documents to criticize its fundraising and data collection practices. The Electronic Frontier Foundation filed a motion to quash the subpoena on Dark Spilver's behalf. Reddit joined. A magistrate judge denied the motion with the qualification that Reddit produce the identifying information on an attorney's eyes only basis. So originally, Judge Kim, I believe it was, had granted the motion to quash, but only partially, and said that Dark Spilver's identity would not be released to the public, but only the attorneys, not even to the religious organization. Of course, Paul DePolidoro, who was representing Watchtower, has made public statements about how the church's law is held over or trumps the non-religious law. And so everyone was very concerned that the attorney's eyes only didn't mean much, that they would just do whatever they wanted with it anyway. Dark Spilver did not consent to the magistrate judge's jurisdiction. Yay! There was a question about whether the judge, being a magistrate judge, could even rule because Dark Spilver had not provided consent to the magistrate judge. Both parties have to provide consent to the magistrate judge. So the decision is a non-final report and recommendation subject to de novo review, which means brand new. So this judge can just start from the beginning. The court, Judge James Donato, concludes that the Reddit postings were a non-infringing fair use of the copyrighted works. Yes! Consequently, the court declines to adopt the recommendation and grants the motion to quash. Background. Woo. The salient facts are largely undisputed. Watchtower is the headquarters of the Jehovah's Witnesses. It publishes and widely distributes religious periodicals such as The Watchtower magazine to disseminate its teachings and interpretations of the Bible. As the Supreme Court has observed, Jehovah's Witnesses take literally the mandate of the Scriptures. Go ye into all the world and preach the gospel to every creature. And we have prosecuted a number of landmark cases championing the First Amendment rights of freedom of expression, association, and religion. Dark Spilver is a foreign citizen who lives outside the United States. Although Dark Spilver's gender is not in evidence, the prior proceedings used he as the applicable pronoun, and this court will do the same. Dark Spilver states that he was raised as a Jehovah's Witness and is a practitioner to this day, but has issues with aspects of the organization's teaching and practice. To explore these concerns, he participated in a Reddit discussion forum directed to former Jehovah's Witnesses. I believe it was XJW. Although he does not consider himself a former member, he joined the forum for the freedom to discuss and debate matters related to the Jehovah's Witnesses without exposing his true identity. He valued the anonymity because he was deeply concerned about being ostracized, shunned, or disfellowshipped, which is what they call it when they kick you out of the Jehovah's Witnesses and then shun you and ignore you, by the Jehovah's Witness community for voicing criticisms or doubts about the organization. In August 2018, Dark Spilver posted 2 items that triggered the subpoena. One item was an image of a solicitation for donations on the back cover of the 2018 edition of The Watchtower magazine. The solicitation, which was captioned, "Which gift can we give Jehovah?" quoted scripture on making contributions and described how to donate online. Dark Spilver believed the solicitation was an advertisement that represented a commercialized approach to fundraising, which was at odds with the traditional teachings of Jehovah's Witnesses. He posted the image to spark discussion about the organization's tone, message, and fundraising practices. He stated that he did not receive any money or realize any commercial gain from this posting. The second item was a screenshot of a chart describing the types of information Watchtower collected, along with citations to the European Union data privacy laws. The apparent purpose of the chart was to summarize how European data collection and disclosure requirements applied to personal information, advanced medical directives, recordings of meetings, judicial committee proceedings, and other Watchtower records. No actual names or other personally identifying information were disclosed in the chart. Dark Spilver reformatted and edited the chart to make it more readable in the post. Dark Spilver states that he posted the chart out of concerns about the scope of the personal and other data maintained by Watchtower. He wanted to alert members to the wide range of information Watchtower collected and how Watchtower stored those records. He was particularly concerned about the treatment of abuse complaints and worried that too many of those records were being deleted. Dark Spilver did not expressly state that he did not receive money or commercial gain, but Watchtower does not contend that he did, and nothing in the record shows otherwise. In December 2018, Watchtower launched proceedings under the DMCA to obtain Dark Spilver's identity. It sent a takedown notice to Reddit under Section 512 of the DMCA, which allows a copyright holder to notify an internet service provider of an unauthorized unauthorized use of protected material and to request that it be removed from the site. Reddit removed the solicitation ad in response to the letter, and Darkspilver voluntarily took down the chart. Darkspilver states that he has stopped posting on the Reddit forum. So, in a sense, the persecution or crusade was successful in that it scared Darkspilver away from talking anymore publicly about his or her concerns about their religious organization. In January 2019, Watchtower requested a subpoena to Reddit under the DMCA. Section 512H allows a copyright holder to request the clerk of any United States District Court issue a subpoena to a service provider for identification of an alleged infringer in accordance with that subsection, and that's 512H. Watchtower represented that it had satisfied all the subsection's requirements and held copyrights for the solicitation ad and chart. At that time, Watchtower held a certificate of registration issued by United States Copyright Office in October 2018 for the November 2018 magazine as a collective work, but Watchtower did not have registration for the chart and did not get one until July 2019. And as we know, right in between there, in about March, there was a ruling that you have to have a copyright registration to pursue a copyright action. That might even mean a DMCA subpoena, although the ruling wasn't specifically about that. The ruling was about copyright infringement actions. But yeah, to get a 512H subpoena, you need to accuse someone of copyright infringement, so it follows that you should have to have a valid registration, not just an application. It obtained the certificate while the motion for review was pending. The subpoena request was filed on its own and not in conjunction with a lawsuit. Watchtower has not sued Darkspilver for copyright infringement. Under our district's operating procedures, the freestanding subpoena request was designated a miscellaneous or MC action. So when you see the number here, it's 319 MC 80,005. And randomly assigned to a magistrate judge. The clerk served on Watchtower a standard form requiring it to consent or decline magistrate judge jurisdiction, including the entry of a final judgment directly appealable to the Ninth Circuit. Watchtower filed a response consenting to have a magistrate judge handle all proceedings in this case, which is going to be important here in a moment. All of these events happened while Watchtower was the sole party of record. Darkspilver did not appear until after Reddit advised him that it had received the subpoena and the EFF filed the motion to quash on his behalf. The docket does not indicate that Darkspilver or his counsel at EFF were given the consent or declination form for magistrate judge jurisdiction, and the record as a whole does not show that they did ever expressly consent. The question of consent was not discussed at the motion to quash hearing before the magistrate judge or in the ensuing written order. I will thank all of the all of the super chats at the end here. The magistrate judge declined to quash the subpoena. Although the subpoena request was issued for copyright purposes under the DMCA, the magistrate judge framed the issue as a matter of First Amendment rights for anonymous free speech. The magistrate judge applied a two-part test developed for anonymous free speech cases. The Highfields Capital and Art of Living. I think we made videos about those, or at least videos about our interpretation of Highfields. Under this approach, the court determines whether the subpoenaing party has made a prima facie or basic showing of the claim for which disclosure is sought, and if so, the balance of the harms to the competing interests caused by granting or denying the subpoena. The magistrate judge found that Watchtower had made a prima facie case for copyright infringement of the solicitation page because it held a copyright registration for the magazine that Darkspilver had copied. The magistrate judge found no prima facie case for the chart because it was not registered, and questioned whether the chart meets the minimum standards of originality required for copyright protection. For the balance of harms, the magistrate judge determined that Darkspilver had established a likelihood that disclosing his identity would chill his speech and expose him to ostracism by other Jehovah's Witnesses. In weighing possible harm to Watchtower, to Watchtower, the magistrate judge turned to copyright law to determine that Darkspilver had made a fair use of the ad and that Watchtower faced no likelihood of harm. The magistrate judge concluded that the balance of harms tips sharply in Darkspilver's favor. Even so, the magistrate judge let the subpoena go forward. The magistrate judge noted that the Watchtower might have been harmed by loss of visitors to its website after the Reddit's postings. The magistrate judge was hesitant to terminate the subpoena before Watchtower had an opportunity to develop this element, and so enforced the subpoena subject to the qualification that access to the identifying information of Darkspilver would be limited to attorneys of record. This provision was intended to alleviate Darkspilver's fear of ostracism. Darkspilver filed a motion seeking de novo review of the magistrate judge's decision. Watchtower opposes any review of the decision by the court. Both sides briefed their copyright issues and other merits of the motion to quash and orally argued the case to the court, which I believe we reenacted the oral arguments back in November, so we'll link to all that. A threshold question is whether this court should review the magistrate judge's decision or whether Darkspilver should have appealed to the Ninth Circuit. The first step in answering this question is to determine whether the motion to quash was a dispositive or non-dispositive motion. A motion to quash typically involves a subpoena for discovery in connection with a pending lawsuit. In that situation, the motion is non-dispositive because it disposes of an ancillary discovery issue, not a party's claim or defense. This case is different. Watchtower obtained the subpoena on a freestanding basis independent of a complaint or litigation. In effect, the subpoena is its own civil case, and the motion to quash is dispositive of the sole issue presented in the case, whether the subpoena should be enforced or not. Once that question is answered, the dispute between the parties is fully decided. Darkspilver agrees that the motion to quash is a dispositive motion. Watchtower does not meaningfully contest this point. The court's independent evaluation of the functional effect of the motion confirms that it is dispositive of the only issue in this litigation. This determination matters because the procedures for reviewing a magistrate judge's decision depend on whether the parties consented to the entry of a dispositive order. Magistrate judge jurisdiction is set by statute or law. With consent of all the parties, a magistrate judge may conduct any or all proceedings in a jury or non-jury civil matter and order the entry of judgment in the case. In that situation, the magistrate judge files dispositive orders that may be appealed directly to the Court of Appeals upon the entry of final judgment. In the absence of consent by all the parties, a magistrate judge may hear all pretrial matters, but may address dispositive issues only in the form of a report and recommendation to a district judge, and not in a final order or judgment. In this circumstance, the parties may challenge the report and recommendation before a district judge. The district judge then makes a de novo or brand new determination about the report and may accept, reject, or modify in whole or in part the magistrate judge's proposed disposition. Consent is disputed here. The record shows that Watchtower expressly consented to the magistrate judge, and Darkspilver never expressly gave their consent. That might seem to be the end of the matter because the magistrate judge's jurisdiction to enter a dispositive order depends on consent from all parties. But Watchtower raises the wrinkle of implied consent in the Roll v. Withrow case. The Supreme Court found that consent to magistrate judge jurisdiction may be established through actions rather than words when the litigant or counsel was made aware of the need for consent and the right to refuse it and still voluntarily appeared to try the case before the magistrate judge. Watchtower reads Roll broadly, but our circuit has construed it to mean that voluntary consent would be implied in limited, exceptional circumstances. Roll did not displace the stringent requirement that a clear and unambiguous expression of consent is required to vest the magistrate with authority. Darkspilver did not make a clear expression. To the contrary, he has consistently denied consent. The case does not have any of the extraordinary circumstances that established implied consent in Roll. The Supreme Court found implied consent because the defendants had been advised of their right to proceed before a district judge, had stood silent when the magistrate judge repeatedly stated her understanding that all parties had consented, and remained without protest before the magistrate judge threw a jury verdict in their favor. None of that happened here. The record shows that Darkspilver's consent was never confirmed or explored by the magistrate judge, and the docket does not indicate that he has ever been advised of the right to appear before a district judge via a consent or declination form or any other means. The record is also devoid of any evidence that might support an inference of consent on the basis of gamesmanship in waiting for the outcome before contesting the magistrate judge's authority. Consequently, in the absence of express or implied consent by Darkspilver, magistrate judge jurisdiction was never created under the law. As a result, the order on the motion to quash is best treated as a report and recommendation from a magistrate judge. The court will review it de novo, but would reach the same conclusions under a more deferential review for a non-dispositive order. The parties have had a full and fair opportunity to file objections and to argue against the order. So finally, we get to the merits of the motion to quash. This case is all about copyright laws and privileges. The parties and the magistrate judge gave substantial attention to Watchtower's copyrights and fair use, but took an additional complication step raised by the application of the First Amendment to anonymous online speech. This was not really necessary to address freedom of expression concerns because copyright law contains built-in First Amendment accommodations. See the Eldred v. Ashcroft case from 2003. The doctrine of fair use provides everything needed to balance the competing interests of the First Amendment and the copyright laws. So in other words, fair use is your First Amendment and copyright law balancing act. The First Amendment concerns are addressed in the copyright field through the fair use doctrine. The fair use doctrine encompasses all claims of First Amendment in the copyright field. There is no need to go further afield or to treat fair use as an element of a broader fair use First Amendment inquiry. The anonymous speech approach was problematic for other reasons too. It is a developing area where the standards are far from settled. Courts have employed a variety of standards to benchmark whether an anonymous speaker's identity should be revealed, and the two-part test the magistrate judge used was created in a context that did not involve the key elements of copyright or the DMCA. Highfields, the source of the test, involved claims surrounding trademark and unfair competition, but not copyright law or fair use. In the Art of Living Foundation case, which the magistrate judge also cited, had a copyright infringement claim among others, but the district court expressly declined to make a fair use determination. The district court followed Highfields instead, although it acknowledged that a court might consider fair use arguments raised in a motion to quash. While the Highfields test certainly has a role in some online speech cases, it is not well suited for a copyright dispute. It begs the question to a degree because the First Amendment does not protect anonymous speech that infringes copyright. See Arista Records. To the extent that anonymity is used to mask copyright infringement or to facilitate such infringement by other persons, it is unprotected by the First Amendment. In addition, the test has no obvious place for the fair use inquiry. The parties and the magistrate judge considered fair use in the context of balancing the harms, but a good argument can be made that it fits much better in determining whether there was a prima facie case of copyright infringement. There is also the prudential consideration that courts should not pass on constitutional questions in the first instance when a case may be resolved on other grounds. Consequently, the court sees no reason to tackle broad online speech issues when an analysis under copyright law and fair use will do. Fair use allows the public to use not only facts and ideas contained in a copyrighted work, but also expression in certain circumstances. Copyright law has never accorded the copyright owner complete control over all possible uses of his work. Congress codified the 4 factors in the Copyright Act to guide determination of fair use. We've gone over them a million times, but here they are. for purposes such as criticism, commentary, news reporting, teaching, not an infringement of copyright when the factors considered shall include the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the original work as a whole, and the effect upon the market or potential market for the value of the copyrighted work, the market usurpation factor. The key principle here is Congress' determination that fair use is not a mere defense to copyright infringement, but rather it is a use that is not infringing at all. And we've seen this in the Lentz v. Universal case. Fair use is a right, not just an affirmative defense. As our circuit has concluded, the plain language of Section 107 means that fair use is not just excused by the law, but is wholly authorized by the law. What did I just say? There's Lentz v. Universal. Anyone who makes a fair use of the work is not an infringer of the copyright with respect to such use. Fair use is a non-infringing use. Consequently, if the fair use inquiry demonstrates that Dark Spilver is not an infringer of Watchtower's copyrighted works, the subpoena must be quashed. The only authorized purpose for the subpoena under the DMCA was to discover his identity as an alleged copyright infringer to protect Watchtower's copyrights. A sworn declaration to the effect that the purpose for which the subpoena is sought is to obtain the identity of an alleged infringer, and that such information will only be used for the purposes of protecting rights under the copyright title. If Dark Spilver establishes that he made a fair use of the copyrighted works, no claim of copyright infringement could plausibly be alleged against him, and the subpoena would not be authorized under the DMCA. The magistrate judge analyzed the fair use factors in Section 107, albeit in a balance of hardships context, and found that they all weighed in favor of fair use. Because no copyright had been registered for the chart at the time of the subpoena and other factors made its copyright status doubtful, the magistrate judge focused on the solicitation ad. Among other determinations, the magistrate judge found that Dark Spilver used the solicitation ad for the purposes of criticism and critical discussion without profit or gain, and that 2, the ad was informational and functional as opposed to creative, and it focused on giving instructions on how to donate online. It was a single page from the back of the November 2018 Watchtower magazine, and thus a small portion of the copyrighted work, and Watchtower had not shown a meaningful likelihood of harm to the value of its work. After a de novo review of the record and the parties' arguments, the court concludes that Dark Spilver made a fair use of Watchtower's documents. This review was facilitated by the fact that the salient evidence is not meaningfully disputed, the record is well developed, and neither side contends that any evidence material to the fair use inquiry is missing. To streamline the analysis, the court assumes that Watchtower perfected a copyright for the ad and chart before it requested the subpoena. This arguably spots Watchtower more than it is entitled to, given the questions about the copyright status of the chart, but the assumption of the clerk clears the deck. But the assumption clears the deck of collateral technical issues in favor of the party opposing fair use. So they're giving Watchtower a pass on the copyright registration in the chart because they say that they don't have to they don't have to address all those things then. If they give them a pass, then they don't have an appeal right or something for the chart and its status, because technically the chart dispute was filed just before, I believe, the decision that said that you must have a copyright registration, and then it put some things in limbo. So rather than leave that door open, they've shut that door, and we're gonna dispose of this just on fair use. The fair use factors in Section 107 are not intended to be applied in an isolated and mechanical way. They should be explored and weighed together in light of copyright's purpose. Every application of fair use is different, and the inquiry must be made on the specific facts before the court on the case-by-case basis. This is what makes fair use and copyright so difficult and expensive, there isn't one hard and fast rule. You can always do this, or you can, if you change 30% of it, then you're in a fair use. No, you always have to look at the purpose and character of the use, the amount of the copyrighted work used, the nature of the copyrighted works, and the market usurpation factor. The doctrine permits and requires courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity the law is designed to foster. With respect to the first factor of the purpose and character of the use, the key question is whether the new work is transformative. That is, whether the use added some new purpose or meaning to the original. There is no material dispute that Darkspilver used the ad and chart for criticism and commentary in a manner fundamentally at odds with Watchtower's original purpose. We saw this in the Sargon Aquila Hughes case. The simple editing of Aquila Hughes' video, we thought she would win, into Sargon's highly critical video, and the fact that their audiences are completely different and that Sargon's audience is very critical of Aquila Hughes is you can't dispute that they're critical of Aquila Hughes, and that's exactly what fair use factor 1 addresses. He put them, that's Darkspilver, put them on a forum, Reddit, expressly dedicated to criticism of Watchtower by former members, so XJW, succeeded in generating a number of comments from other users critical of Watchtower, so the comments come into the fair use inquiry in this case, and declared that his sole purpose was to criticize the organization and spark discussion about it. That literally means he declared in court that that was his purpose. This was a transformative use. It is true that he copied the solicitation ad and chart largely in their original and unaltered states, but physical changes are not required for a use to be transformative. See Katz v. Google. The use of a copyrighted work need not alter or augment the work to be transformative in nature. And Seltzer v. Green, a work can be transformative with few physical changes or comments to the original. What matters is that Darkspilver used the ad and chart to express something new with further purpose or different character, altering the first, or original, with new expression, meaning, or message. That's from Campbell v. Acuff Rose Music. The something new was criticism of Watchtower's fundraising and data collection practices, a quintessential fair use. Quintessential fair use. Where have we heard that before? The H3H3 case. So this is a quintessential fair use to post something online in a critical fashion. That was completely transformed. That use completely transformed the purpose and expressive content of the ad and chart, regardless of whether their physical text was changed. See the Swatch case. Courts often find such uses of unaltered reproduction transformative by emphasizing the altered purpose and context of the work as evidenced by the surrounding commentary and criticism. Use of exact copies of photographs as search engine thumbnail images were also transformative because the original use as fine art was altered. That's in the Kelly versus Aribasoft case. There is also no serious dispute that Darkspilver did not use Watchtower's works for a commercial purpose. He expressly declared that to be true, and Watchtower has not provided any evidence to the contrary. Watchtower makes a passing comment that the Reddit post might have boosted Darkspilver's status in social media, but that suggestion is entirely conclusory. That's interesting. Might have boosted his social media status. And Watchtower never explains how posting some criticisms of the Jehovah's Witness on a Reddit forum directed to former members could ever translate into a profit-making enterprise for Darkspilver. For the second factor, a plain reading of the ad and chart shows that they were strongly in the nature of functional and instructive documents. They were factual works, instructions on how to donate online, and a summary of potentially applicable European Union data laws that are light years away from the creative works at the core of copyright protection. Light years away from copyright protection. In general, fair use is more likely to be found in factual works than in fictional works. In addition, the solicitation ad had been published before Darkspilver used it, which also weighs in favor of fair use under this factor. Under the third inquiry, the record shows that Darkspilver used a quantitative and qualitative amount of the documents proportionate to his message. The extent of permissible copying varies with the purpose and character of the use. The purpose of the claimed fair use made it necessary to copy the entire work, as copying less would reduce its usefulness. Whether the solicitation ad should be treated as a separate work, as Watchtower now suggests, or as one page of a collected work as it was copyrighted, Darkspilver copied what was reasonably necessary from it, and the chart, to make his criticisms and comments understandable. He did not help himself to an oversized portion of Watchtower's works for his critical message. The fourth factor looks at whether the new use has an effect on the potential market for or value of the copyrighted works. This factor has been called the most important fair use element because it protects the incentive to create. Even so, a use that has no demonstrable effect upon the potential market for or value of a copyrighted work need not be prohibited to protect that incentive. That is the situation here. To start, Watchtower did not present any evidence to establish a potential market or value for the ad or chart. There is no dispute that the Watchtower magazine is distributed to readers without charge, and that the chart was not published or distributed externally. In addition, Darkspilver's use of the ad and chart for criticism was fundamentally contrary to Watchtower's purposes. There is no likelihood that this critical use could substitute for the originals and thereby harm their potential market or value. Watchtower was not in the business of publishing or licensing its works to criticize its fundraising and data collection practices, which effectively removes the very notion of potential harm here. Watchtower no doubt disliked and was possibly offended by Darkspilver's use of its works, but that does not satisfy the lost value inquiry. The chart has the additional factor that Watchtower did not obtain a certificate of copyright for it until after challenging Darkspilver's use. That further undercuts any possibility of loss of value for the chart. Due to plaintiff's attempt to utilize copyright as an instrument of censorship against unwarranted criticism, there is no potential market for its work. Rather than establishing a potential copyright market or value, Watchtower speculates that the Reddit postings might have diverted visitors away from its website. This was the primary reason why the magistrate judge let the subpoena go forward. This point is not well taken. To start, it runs counter to the principle of law that a diversion or suppression of demand from criticism is not a diversion or suppression of demand from criticism is not a cognizable copyright harm. There is crucial difference between biting criticism that merely suppresses demand and copyright infringement which usurps it. A parody, for example, can kill demand for the original without causing a copyright injury. This makes the premise of Watchtower's theory of harm doubtful as a matter of law. Watchtower also made no effort to adduce any facts that might have made its theory less speculative, such as evidence of reduced or changed website traffic after the Reddit posts were made. Nor does Watchtower explain how the posts were even capable of usurping copyright value. This is not a case where a bootleg copy of a work was pirated to capture sales the original creator should have made. To the contrary, Darkspilver used the Watchtower documents in a way entirely different from and critical of Watchtower's use. Overall, Watchtower does not meaningfully dispute any of the fair use evidence in the record. Instead, it offers the general challenge that the inquiry is woefully premature because fair use is an affirmative defense that can't be considered unless and until a complaint is unfiled. This is a surprising proposition, given that Watchtower was required to evaluate fair use before sending its takedown notice to Reddit. See the Lentz case. A Lentz v. Universal required copyright owners to consider fair use before sending takedown notices. and that Watchtower and its attorney represented that it had done so. They are not well situated to now say the inquiry should wait. In addition, Watchtower has not demonstrated that it is missing any critical evidence for the fair use analysis, or that it has been disadvantaged in any way by examining fair use for the motion to quash. Watchtower's position is also contrary to the law. Our circuit has expressly held that calling fair use an affirmative defense is a misnomer, citing Lentz. Fair use is an authorized use and consequently is distinct from affirmative defenses where a use infringes a copyright, but there is no liability due to a valid excuse, e.g., misuse of copyright. Curiously, although these holdings are plain as day in Lentz, Watchtower failed to acknowledge them in its briefs, even though it cited Lentz for other uses. The court is just absolutely eviscerating Watchtower for trying to eat its cake and have it too, or have its cake and eat it too. I like the second version of that. Watchtower also suggests that Darkspilver has turned the motion to quash into an improper religious inquiry by referring to potential sanctions of shunning and disfellowship. Not so, says the court. Watchtower is perfectly free to organize its internal disciplinary practices as it sees fit, without interference from the court. As this order makes clear, those considerations play no role whatsoever in a fair use analysis, and the court has not relied on them for any findings here. They are a non-event for purposes of this order. For the sake of completeness, the court also rejects Watchtower's suggestion that Darkspilver waited too long to oppose the subpoena. Watchtower refers to a deadline under Rule 45, but that only applies to the person commanded to respond to the subpoena. That was Reddit, to whom the subpoena was directed. Darkspilver was permitted to move to quash in a timely fashion, which he did. The record establishes that Darkspilver made a fair use of the Watchtower ad and chart. Consequently, he did not infringe Watchtower's copyrighted works, and there is no basis in the DMCA for a subpoena to compel disclosure of his identity. This is not a matter of limiting disclosure to outside counsel only, but that disclosure is not permitted at all under the law. The motion to quash is granted. Yes! It is so ordered. James Donato, United States District Judge, March 2nd. This was just issued last night. Holy mackerel, that is an awesome opinion. I don't know if you see how excited I am, but that is Lentz Plus. That is showing us that you can post critical material on Reddit. The comments do count. The title does count. The audience, the venue do count towards that fair use analysis. Fair use is a right, not just an affirmative defense. The courts are prepared to uphold Lentz and to hold copyright owners to the requirement that they consider fair use before they issue takedown notices, DMCA subpoenas, or copyright infringement cases. That is an amazing opinion, and I frankly expect that to be cited as persuasive authority and maybe even binding authority in the future. It's not an appeals court case, so it's not technically binding upon other courts, just maybe consistent in the Northern District of California. But it's definitely a very persuasive opinion and sort of a summary opinion where you can go through and look at all the case sites that they used, and you can refer to those cases when you make your argument for a criticism or commentary or fair use purpose in a similar case throughout the United States. I think this is an amazing opinion. I think it will be used for time immemorial, and I'm really excited. This is really awesome that we got such a quintessential fair use ruling from Judge James Donato of the Northern District of California. This is absolutely amazing.
So
such a big deal.
Yeah, I'm really happy because I really felt like this was an abuse of copyright, and I don't like that.
Yeah.
And I have a couple questions from chat.
Sure.
If you're okay with that.
Yes.
One of the questions is whether the EFF can make a motion to get their attorney's fees covered. Because this is a subpoena, not really a trial, and there was no complaint.
17 USC 505, I believe, does allow a prevailing party to request their reasonable cost and attorney's fees, which is limited now. We had another ruling last year about this time that said that you can only get your court costs, your attorney's fees for appearing in court and filing things in court, and your transcript fees. So if they paid for the transcript, which I'm sure that they did, the attorney's fees for responding and appearing in court, and any court costs themselves, like the filing fee for a complaint is $400 or something. But that would have been a cost to the plaintiff. So yes, they can request it, but it is not a shall grant. It is a may grant. So in other words, it doesn't say the court shall grant, it says the court may grant in its discretion. So the court will balance some factors of the various parties' arguments. I think the fact that Watchtower filed against the chart without a copyright registration and didn't apparently consider fair use properly, I think the court will consider those, and maybe you'll see an award of attorney's fees. So this might not be the end of the Dark Spilver case in that sense. And of course, it might not be the end in the sense that both parties have a right to appeal this ruling. Of course, Dark Spilver won't appeal it because they got exactly what they want, but maybe Watchtower will appeal it. And I kind of hope that they do, because they have a big time losing case here. And if they then lose at the appeals court level, then that means that we'll get some kind of potentially very precedential opinion on the level of Lentz. But I doubt that they're going to appeal it, because it's really not going to go in their favor, and I think they know that. More questions? While we're waiting, thank you very much to the super chats. Thank you to Elephants in the Forest for your $2 Australian. Thank you to JW Suicides for your £2. Thank you to Jax Merrick for your $5. And thank you to Jan Negrey for your 5 Polish zloty.
Unmute yourself.
Did I mute myself?
Sorry, Mr. Leonard. Don't want to interrupt you if you're talking right now.
I accidentally muted myself on Discord.
Yeah,
sorry.
We noticed. Yeah, we didn't want to interrupt you, but we also didn't know.
Okay, so any more questions?
Perhaps some people were getting confused about what a dispositive motion is and why that was important. So my understanding is dispositive comes from like to dispose of, as in it would end the action. And that's important for an appeal, that you usually can only appeal things if they're final or dispositive, versus if it's, just a random decision halfway through a trial, you would usually wait until the end of trial to appeal it.
Yeah, let's go over that, because I'm not 100% clear on the exact definition myself. But yes, my understanding is that a non-dispositive and so here they say in a different case, a motion is non-dispositive because it disposes of an ancillary issue, not a party's claim or defense. So a dispositive motion gets rid of a party's claim. So in other words, in this case, it was copyright infringement. Let's say you have a completely different case where it's copyright infringement, trademark infringement, patent infringement, and all that. If a motion disposes of any one of those, not even just all of them, but any one, or disposes of a party's defense. So like affirmative defense of fair use is a defense. So if the result or a ruling of a motion disposes, eliminates that defense, then that is a dispositive motion. A non-dispositive motion disposes of an ancillary issue. In this particular sentence, citing Flam v. Flam, a case we haven't gone over, it was an ancillary discovery issue, discovery of relevant evidence. And so that was a non-dispositive motion because it disposed only of a discovery issue, not of a claim or a defense.
So one of the provisions, I want to say DMCA 512F, is that if somebody issues false DMCA stuff, that you can sue them for misrepresentations.
Yes.
Would Dark Spilver be able to maintain his anonymity and also sue?
Darkspilver could counterclaim or file his own lawsuit for a DMCA 512F misrepresentation claim. The court would have the discretion as to whether to allow them to proceed through a motion for a protective order. So they would file the complaint as a John Doe or maybe just as the pseudonymous Darkspilver, and then ask for a protective order protecting Darkspilver's identity and citing all the reasons for that. If the court did not grant that protective order, then maybe they can just get out of the case and say, okay, well, we're not going to go forward if we can't get a, what is Google doing? If we can't get a ruling in favor of protecting Darkspilver's identity. Right now, given that the EFF represented probably pro bono, I don't have any knowledge of that, but the EFF likely represented pro bono. For the good of the profession, for the good of the cause, for the good of Darkspilver. That's what pro bono means, for the good. I doubt that Darkspilver wants to go any further down this rabbit hole or open a can of worms or expose themselves to anything more, especially considering that it appears that this effort actually worked in a sense, in that Darkspilver is no longer participating on the XJW Reddit forum, having apparently been scared out of further criticism of their religion, lest they become ostracized, disfellowshipped, shunned, etc. Back to that DMCA misrepresentation claim, just so everyone's clear, the other reason why they might not bring it is it only works, they only succeed in their claim if Watchtower did not form a sincere good faith belief that the information was copyright infringement. So in other words, the evidence and testimony will come into it as to how they formed their belief that it was a copyright infringement, the posting of the chart or the posting of the ad. And if the evidence shows, and Darkspilver is unable to contest, that they did consider fair use, that they thought it was not a fair use, and that they reached that in a sincere effort to determine whether it was fair use. And I've, again, had one of these cases where my client was in the wrong, but did form a sincere good faith belief as to whether it was copyright infringement, and then upon further investigation realized that it was not copyright infringement, and then immediately dropped the copyright claim literally like 2 days later or something. So there was a takedown that my client realized that the takedown was not fair use, and then they retracted their claim. The court considered, or rather that went to arbitration, the arbitrator considered my client's direct testimony that the issue, or that the misrepresentation had to be a willful, a knowing, or should have known misrepresentation, or like a willful blindness, and that my client was not willfully blind. My client had not made a knowing misrepresentation or should have known. My client tried to evaluate fair use and just got it wrong. But it was a sincere, good faith attempt to evaluate fair use. And so my client still won, and we still got our attorney's fees back for the most part. So that is how that works. And so if the Watchtower Bible and Tract Society, Paul DePolidoro, Jehovah's Witness organization did consider fair use, and the evidence will show that, there's no point in going through with a 512F misrepresentation claim, because you won't succeed, and it'll just be an elongation of these parties' time together. And I think Darkspilver really wanted out, and so I think that's probably in their best interest. Any other questions? Otherwise, I'll do my outro, and you guys have a good day.
Have you done the super chats?
I did thank the super chats while I was accidentally muted on Discord.
Excellent.
But I was only muted on Discord. I was still unmuted here.
Yeah, we didn't know when to chime in and tell you that you were muted, because we didn't have a way of knowing. It was
Sorry about that. So thank you for joining me. I am Leonard French, your favorite copyright attorney. This is Lawful Masses, a community-supported legal education channel where we try to bring you stories like this and teach you about how the law, especially copyright law, works. Because an informed citizenry will be better behaved, will understand their rights, will know when to defend themselves, when not to, and will understand why things are happening, why YouTube has to comply with DMCA takedown notices, why Reddit opposed this subpoena, why YouTube gets caught in the middle between copyright owners and users posting videos, why demonetization really has nothing to do with copyright. So an informed citizenry is very important to us. And we could not bring this to you without the financial support of our supporters. For example, in the month of March, I would like to thank the following people who have donated more than $50 or more. Wes Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, that's Sargon's lawyer, Jared Bales, and Anders Thorenfeldt. And there are a few new $50 plus supporters that will begin their support in April. So I'll read you, and you'll be on the crawls and everything in April. There are also a list of $5 plus supporters who will be in the descriptions of every video that drop. And we have other supporters who donate less than $5 or donate under a tier that does not get recognized in the descriptions. But I would like to thank them all as well. Your donations really do add up, really do support us, help us pay our people, help us pay for our legal research so that we get alerts on cases like this. One of our legal research systems costs $1,600 a year. Another one costs $200 a year. So these things really do add up to a significant monthly expense that I need to cover or else. So thank you so much for your financial support. Thank you for sending in your stories. Thank you for joining me today for this quintessential fair use case of Dark Spilver versus Watchtower Bible and Tract Society. What a David and Goliath moment, to use a religious metaphor. That is really remarkable. Anyway, I really enjoyed this one. I love you all. I'm Leonard French, your favorite copyright attorney, and I will see you in the videos that drop. I think the next one is the Christopher Hook case where he got hit with a bunch of sanctions. We're going to see how many and why. And then we will also be going over a case where the Supreme Court has agreed to hear a challenge to Obamacare. This might be the end of your health insurance, at least if your health insurance is through the Affordable Care Act or Obamacare, because the Supreme Court might be ruling in favor of canceling the law or killing the law in its entirety. We'll see what might happen there in the next one. Love you all. Bye.
Wait.
Wait.
Somebody wants you to light your hat up. Because you never turn the lights on during your stream.
Oh, there's lights? Wait, there's lights.
Remember? If you squeeze the pause, I think.
I forgot the lights. I don't know. You can't really see the lights too much because of my color correction. And I don't know, maybe I can turn down my lights here. Yeah, if I turn down my lights, now you can see the hat blinks. So there you go.
I really enjoyed the hat on this stream, I just have to say. Good call.
Yeah.